This episode is brought to you by Nordstrom. Summer's almost out and fall's calling. Luckily, Nordstrom has everything you need for the season ahead, all under $100. Discover new arrivals from your favorite brands like Mango, Princess Polly, Wave, Free People, BDG, and more. Whether you're planning a last-minute getaway, heading back to class, or refreshing your office looks, you'll find the latest trends and beauty must-haves without breaking your budget. It's easy, too, with free shipping, free returns, and in-store order pickup. Shop today, in stores, and at Nordstrom.com.
She's made up her mind to live pretty smart. Learn to budget responsibly right from the start. She spends a little less and puts more into savings. Keeps her blood pressure low and credit score raises. She's gotten debt right out of her life. She tracks her cash flow on her spreadsheet at night.
Boring money moves make kinda lame songs, but they sound pretty sweet to your wallet. PNC Bank, brilliantly boring since 1865.
The Stone Zone, entertaining and informative
on the Red Apple Podcast Network.
Former Trump impeachment attorney David Schoen, criminal defense attorney extraordinaire, who ably represented Donald Trump in his second impeachment trial, joins us now because he believes that this precedent could hit Obama squarely in his legacy. David Schoen, welcome back in to the Stone Zone.
Thank you very much. Always an honor to be with you.
So, David, we saw a clip the other day of the president. He was asked directly whether this recent Supreme Court decision regarding the president having immunity would protect Barack Obama from prosecution based on everything we know. And I think he said kind of cavalierly, yes, it probably helps him a lot. But you put forward a very shrewd analysis that the Democrats now have the risk of being hoisted on their own petard, so to speak. Lay this out for us.
Yeah, sure. So President Trump was absolutely right when he said that the immunity decision, Trump versus United States, would help former President Obama evade prosecution at this point. All of this is based on the idea, the premise, that the evidence shows, as Director Gabbard has said, that former President Obama was directly involved in a scheme with others to skew the election results, undermine the will of the people in the election. If the evidence doesn't show that, then the discussion is simply academic. But assuming for these purposes, the evidence shows that, President Trump was right that the immunity decision helps President Obama as a matter of first course. But what doesn't help him with is the impeachment process. Without any question, 100%, according to the Democratic members of the House of Representatives and the Senate vote in the second impeachment trial, former President Obama absolutely can be impeached and convicted in a trial before the Senate. I argued vigorously against that position, that a former president is not subject to impeachment and conviction in a Senate trial once out of office, because removal from office is a prerequisite for an impeachment concept. However, the House managers argued some 30 pages in their brief that that's not at all the case. The history and other interpretive tools tell us that without any question, a former president can be impeached and convicted, going back as far as George Washington and any other former president. And they go on to explain all of their reasons why, and why there are two separate provisions in Article 1, Section 3, Clause 7. One provides for removal, and the other provides for disqualification from holding future office. And that's why their reason is essentially a former president can be impeached and convicted, because they say it's just as important that person could have followers even after leaving office. And so the person should never be able to hold high office again. But in fact, they went much further. And this is particularly telling, it seems to me, if the evidence shows what Director Gabbard has suggested it shows. It goes right to the heart of the democracy, the power of the vote, the will of the people exercised through their vote. What they wrote, the House managers, Jamie Raskin and crew, wrote in their brief was that the framers anticipated the risk of someone being out of office, and they explained that presidential abuse aimed at our democratic process itself was the single most urgent basis for impeachment. Well, of course, the evidence we're talking about here, if it's proven, goes to the very core of the democratic process, and therefore there would be an imperative to impeach former President Obama, because as the House managers wrote, if you do let someone get away with attacking the democratic process, it'll send a horrible message throughout the rest of American history. And so I think, their words are very powerful in there. But this goes beyond it, Roger, and I think this is an important point to make. The immunity decision, as I say, and President Trump said, as a matter of first course, would probably prohibit prosecution. Some have suggested otherwise. And the key here is understanding what that decision held. Very simply, it held that if something is within the core official acts of the president, then it's absolutely immune from criminal prosecution, just as it is from a civil lawsuit in Nixon versus Fitzgerald. And if it's within that outer limit of the official acts, it's presumptively immune. There's presumptive immunity. Something that's not an official act wouldn't have the benefit of immunity. But we're also not allowed to look into the motive behind the action. So let's just say that the evidence is there. However, former President Obama and his colleagues can spin a tale so that this was somehow his view of, ensuring the integrity of the election, something like that. So he has the benefit of immunity. Now he gets impeached by the House. Majority of the House impeaches him, and he gets tried before the Senate and convicted because the evidence is overwhelming. Let's just assume for argument's sake. Now, according to Article 1, Section 3, Clause 7 of the Constitution, in my view, he would be able to be prosecuted criminally. Why? Because the text of the Constitution expressly provides for it in that case. And that, in the case here, it says, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, etc. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. And so one would argue this would supersede that immunity decision because it's been an intervening event, an impeachment and a conviction by the Senate under Article 1, Section 3. So therefore, it triggers this clause, and it could be indicted, tried, and convicted by a jury criminally. This, by the way, is perfectly consistent with an argument that President Trump made in the immunity case, and that is using the impeachment clause. He argued in the position that was rejected by the Supreme Court. He argued that the only way a person can be tried criminally is if they're first convicted after an impeachment trial in the Senate. So it's perfectly consistent with his view on that, but it's in the language, the express language of the Constitution.
So, David, President Donald Trump filed a civil lawsuit in March of 2022 in the U.S. District Court for the Southern District of Florida, specifically against Hillary Clinton, the Democrat National Committee, and others, alleging a conspiracy to falsely tie his 2016 presidential campaign to Russia. The case was dismissed in September of 2022 by U.S. District Judge Donald M. Middlebrooks, a Clinton appointee, who described it as being without merit, as having glaring structural deficiencies, and he imposed sanctions of nearly $1 million against President Trump and his attorney in the case, Alina Habba. Now that the assertions in that lawsuit have been proven by the declassification of these documents to be completely and totally true, what happens to this lawsuit, and more specifically, what happens to this $1 million fine?
Yeah, well, that's a great question. On the one hand, federal courts make it very difficult to come back and revisit a final judgment in the case. I would add, by the way, Judge Middlebrooks is not one of my favorites, but that's beside the point. So anyway, the federal courts make it difficult to come back and revisit a final judgment. However, there are tools under Rule 60B of the Federal Rules of Civil Procedure that in certain circumstances do allow it. Some of them are time sensitive, but some aren't. There's a catch-all clause, 60B6. But it may be that 60B4 and 60B5 apply here because, as you said, there's a fine involved here of $1 million. If you can show extraordinary circumstances, and certainly it seems like extraordinary circumstances to uncover previously classified or secret documents that now expose events that are at odds with the basis on which the judge made his judgment. That's an extraordinary circumstance, it seems to me. But beyond that, they're using that judgment for prospective purposes. It's not just that the judgment sat there and had some impact at that time. It can be used now to collect on that judgment, and one would argue that it's an invalid judgment for the reasons the extraordinary circumstances of this disclosure explain, and therefore another mechanism to get back in could be either 60B5 or 60B4, arguing that because we can't allow a void or invalid judgment to be used for prospective purposes. How unfair would that be? You were wrong, Judge, but we're still going to let you collect $1 million in sanctions for the other side?
So yesterday, John Solomon with Just the News reported that the Attorney General, Pam Bondi, had ordered a federal prosecutor to begin presenting evidence to a grand jury against those who were exposed in the declassification of documents by Tulsi Gabbard. But the speculation was that grand jury was in Florida rather than in the District of Columbia. I obviously welcome that news if it is correct, but I'm trying to determine why that venue. And here's a theory. The raid on Mar-a-Lago, since it was actually designed to seize evidence of the guilt of those involved in the Russian collusion hoax, was part of a continuing seditious conspiracy, continued until that date, and that took place in Florida, thus allowing the case to be pursued in the Sunshine State. Now, that's so much for my amateur lawyering. How could this case against Brennan, Comey, Clapper, Biden, Rice, Weissman, Mueller, this list goes on and on, how could this be pursued someplace where there could actually be a fair trial and where there's a reasonable probability of conviction based on the evidence?
Yeah. So good question again, and I think your analysis, your theory is a good one. But remember, in the Florida case, they convened a grand jury in Washington, D.C. to hear much of the evidence was then used or to be used in the Florida case. Here, I think there could be a theory also. First of all, the point is you want it outside of D.C., ideally, because, it's one of the jurisdictions in the country in which, the voters overwhelmingly Democratic, and we see a lot of political decisions from the judges in that jurisdiction and from juries. Human nature, in a sense. I think one could make an argument that if the evidence here really is evidence of seditious conspiracy under 18 U.S.C. 2384, or in some offense that relates to undermining the vote, the will of the voters, and theoretically it has an effect in every state in the union, and therefore a grand jury could be convened any place. I think that's one theory that could be, floated out there. Every American has a stake in seeing justice done because it affects the vote of every American one way or another. But we have to see, I think, what the evidence is, what the conduct at issue was. It might be that if there were discussions like this, some discussions took place over the telephone or the internet from various places outside of Washington, D.C. I don't know. We have to see what the evidence is, I think.
I appreciate that analysis. Hope springs eternal that this trial the trials will take place in a jurisdiction other than the District of Columbia. I personally have been through that meat grinder, as I said earlier in the show. In the District of Columbia, the Constitution, the law, the facts, the evidence, the rules, none of these things matter when the court is in order. It is the most politicized jurisdiction in the country. In my particular case, when we learned that the jury forewoman who denied during jury selection and the trial that she had any knowledge of me or my case had been attacking me on Facebook and Twitter by name, but had those postings on a private setting, once that was revealed, the judge actually ruled that none of that was evidence of bias. Wherever you do, don't touch that dial.
This is the Stone Zone with Roger Stone.
Greg Kelly here for Colonial Metals Group. China's leading the largest anti-American alliance since World War II, one that's already dumped U.S. bonds, grabbed 43 million acres of our farmland, and is plotting to dethrone the dollar. That's why IRA and 401k savers are protecting their savings with gold. Go to freegoldguide.com/Kelly or call 800-655-5186 for your free gold guide on how to protect your wealth with gold 100% tax-free.
If you work as a manufacturing facilities engineer, installing a new piece of equipment can be as complex as the machinery itself. From prep work to alignment and testing, it's your team's job to put it all together. That's why it's good to have Grainger on your side. With industrial-grade products and next-day delivery, Grainger helps ensure you have everything you need close at hand through every step of the installation. Call 1-800-GRAINGER, click Grainger.com, or just stop by. Grainger, for the ones who get it done.
This episode is brought to you by Espolón Tequila. Slow, sticky, snoozy. They call these the dog days of summer. But Espolón? They don't do boring. Welcome to the Marg Days. Espolón Tequila. 100% blue Weber agave, born to shake up your summer. Just add lime, agave, and a little attitude. Visit EspolónTequila.com. Espolón Tequila, 40% alcohol, volume 80 proof. Copyright 2025 Campari America, New York, New York. Drink responsibly.
This podcast is brought to you by Carvana. Buying a car shouldn't eat up your week. That's why Carvana made it convenient. Car buying that fits around your life, not the other way around. You can get pre-qualified for an auto loan in just a couple of minutes and browse thousands of quality car options, all within your terms, all online, all on your schedule. Turn car buying into a few clicks and not a full week's endeavor. Finance and buy your car at your convenience on Carvana. Financing subject to credit approval. Additional terms and conditions may apply.
This is the Stone Zone. Now, get in the zone. It's the Stone Zone. Here's Roger Stone.
And we're back in the Stone Zone. We're talking to perhaps the preeminent criminal defense attorney in the country today, David Schoen, who very ably represented President Donald Trump in his second impeachment trial on the floor of the U.S. Senate. David, you were back in the news only days ago because of this vicious effort to smear Donald Trump as having had a somehow inappropriate relationship with Jeffrey Epstein, who was convicted of sex crimes in Florida and was indicted in 2019 in New York on one count of child sex trafficking and a second count of the conspiracy to engage in child sex trafficking. But you revealed to the American public that you discussed this matter with Jeffrey Epstein just before his death. Why don't you take it from there?
Sure. Well, as one might imagine, any criminal defense lawyer in meeting with a client who's facing a federal indictment would want to know what kind of leverage that defendant might have to help himself in some kind of deal or something like that. I happen to have made it a practice in my practice that I don't represent cooperators, but everyone ought to be advised of that opportunity. I just don't believe it as philosophically that one should turn against friends, all that, but everyone should have that opportunity to help him or herself in a case, and a lawyer has an obligation to explain that to the client. I won't, I never go into attorney-client privilege discussions regarding any of my conversations with any client. However, in this case, I expressly discussed with Jeffrey Epstein whether he had anything, any information that could help him by hurting Donald Trump. That is, any information that Donald Trump did anything illegal or improper. And had he not authorized me to, I wouldn't have disclosed the answer to that. But he did. And he said to me, in no uncertain terms, that he had no information that could hurt Donald Trump in any way because Donald Trump had not done anything illegal or improper with him. And then he made it clear that he wanted that known. So that's why I've revealed it now. I revealed it in response to Mr. Musk's tweet suggesting that maybe President Trump was withholding documents here because he had something to fear for himself. I thought that was an outrageous, even suggestion to make, and I knew it not to be true, so I felt an obligation to come forward. But again, I would not have had Jeffrey Epstein not authorized it. He felt strongly about it. He didn't want anybody, but particularly Donald Trump, and I can explain why, being falsely accused of having been engaged with in conduct with him it was illegal, etc. With Donald Trump, they had a friendship like, tens or hundreds of wealthy, successful people in the world had with Jeffrey Epstein, some friendship on some level. And Donald Trump, among all of the other people, is the one person who cut off that relationship. Cut it off for a couple of reasons, but cut it off, we're talking, decades ago. And so, that hurt Epstein to some degree, but he also respected, appreciated. But in any event, whether he wanted the friendship back or not, he made clear that Donald Trump had done nothing illegal or improper with him, and that he wanted that made known. Now, some suggested, oh, gee, that's convenient. Here you represented Donald Trump, his impeachment trial. Now you're saying this about Jeffrey Epstein. I didn't know Donald Trump at that time. We're talking about 2019. I got a call to represent President Trump in his impeachment trial 2 weeks before the impeachment trial in 2021. So, one can suggest anything they like, but I've got no other motive here, except that I think it's important to bring the truth out. I think what's going on here, quite frankly, in my view, is an attempt. But look, the left and the right have separate agendas here. But on the left, to drag this thing out, to make it sort of Mueller 2, try to paralyze the government, try to distract from all of President Trump's accomplishments, and help themselves in the midterms with these, suggestions of maybe something improper. But it defies logic. You can be sure the accusers of Jeffrey Epstein filed lawsuit after lawsuit with lawyers who have made millions of dollars against anyone who those accusers said they had any illicit affair with through Jeffrey Epstein. So you can imagine that if some accuser were out there and had some knowledge about Donald Trump, they would have filed a lawsuit a long time ago.
I'm afraid we're going to have to leave it there. I want to thank our guest, David Schoen, and for our many guests. Until tomorrow, God bless you and Godspeed.
Thanks for listening to the Stone Zone with Roger Stone. You can hear the Stone Zone with Roger Stone weeknights at 8 on 77 WABC. If you like the podcast, share it with your friends and listen anytime at WABCRadio.com and download the WABC Radio app. Hit that subscribe button on all major podcast platforms. Plus, follow WABC on social on Instagram, TikTok, Facebook, and X. See you next time for a new episode, so you never have to wonder.
What the heck is going on here?